Hi everyone, and welcome to today's Boundless Immigration Live Q&A about immigrating children to the United States. My name is Maggie Riley. I'm the Immigration Law and Policy Analyst here at Boundless Immigration, and I wanted to spend some time today providing some general information about immigrating your children either for green cards or on K-2 visas into the United States. We received a couple questions from y'all over the last day or two, so we're going to try to address some of those while also providing general information about bringing your kids to the country, be they your natural-born children, adopted children, or stepchildren. So I'm just going to give a couple minutes here to let folks trickle in and join us for our conversation before I get started. We're going to be talking a lot about the green card process for your children as far as immigrant visas and as well K-2 visas for children who are coming through a fiancé visa application. I am going to steer clear a fair bit of derivative and acquired citizenship questions, and I'll touch on sort of what that is as we get to it, but we're going to be talking a lot about bringing your children to the United States and getting them their green cards. So before we jump in, I do want to give a little bit of a caveat. So my name is Maggie Riley. I work at Boundless Immigration, and I am a licensed immigration attorney. However, I don't represent private clients, individuals, or families. I just work for Boundless Immigration. So that means that the information I'm providing is general information, and it is not to be taken as legal advice. I can't comment on anybody's specific case or situation. I can't give advice on that, but I can give general information about how the system works and tips and tricks that can be used and generally understood to help you figure this thing out. In some situations, it is truly going to be best to hire an immigration attorney, especially if you're dealing with questions about derived or acquired citizenship, because that's when we're going to start getting into a lot trickier, sort of more nuanced definitions and areas of law. So all that being said, please keep in mind this is general information. This is not personal legal advice, and let's go ahead and get started. So one of the first things I wanted to touch on is what is a child in immigration law? The definition of child in U.S. immigration is not necessarily the definition that it is for the rest of us. And so we're going to talk a little bit about that. Children can gain green cards or entry into the country, I should say, through a couple of different methods. Sometimes it's going to be through an immigrant visa. Sometimes it could be a direct sponsorship by a U.S. citizen parent. Sometimes it is a sponsorship by a step-parent through their own biological parent. There is also the opportunity for some folks to come in as derivative beneficiaries. So we got a lot of nitty-gritty terms to get into, so I will try and break this down a bit for us. So starting with green cards, especially marriage-based green cards, which is something we deal with a lot here at Boundless. Children can gain a green card as a derivative beneficiary through a parent's application with USCIS. So that's the parent files an I-130 and an I-485, or if the child goes through the immigrant visa process at the consulates, and that's filing an I-130 and a DS-260. The parent in this situation is the lead beneficiary. So you have your sponsor, the lead beneficiary, and then the derivative beneficiary, who is the child of the lead beneficiary. However, only green card holders can sponsor a family member and the derivative beneficiary on the same I-130. So what that means is, and this is a little bit confusing, seems a little backwards even for immigration attorneys. If you are a U.S. citizen and you are sponsoring a spouse and your spouse's child, you have to file a separate I-130 for the spouse and for the child. A sponsor who is a green card holder or an LPR only has to file one I-130, and that's the I-130 for the spouse, who's the lead beneficiary. The child of the beneficiary can be included on the one I-130, and they sort of ride along on that petition. We'll talk a little bit more about how this can impact some situations further down the road in just a moment. So again, if you are a green card holder and you're petitioning for your partner and your partner's child, one I-130 will rule them all. If you are a U.S. citizen and you're petitioning for your partner and your partner's child, you're going to have to file an I-130 for each person. So once you move on from there, one of the questions that we had received related to this, and it's very pertinent, is what is a child in immigration law? So this is where things get a little bit funny. For most of us, a child means something not too specific, I suppose, but in immigration law, there are very specific rules about it. So in immigration law in the United States, a child is someone who is unmarried and under age 21. Once your 21st birthday hits, you are no longer a child for immigration purposes. Now, this is a general definition. It can vary somewhat depending on the citizenship context versus the green card or other visa context. But by and large, in U.S. immigration, a child is an unmarried, under 21 individual. So what this means is that, and I'm sorry, an additional piece of that, unmarried, under 21, and the child was born either in wedlock, which means that your parents were married at the time you were born, or you're born out of wedlock, which means your parents were not married. That doesn't necessarily change the definition. It's still age 21 and still unmarried. It just changes some of the parameters about when and how you may be eligible for other immigration benefits. I just wanted to make sure I touched on that. So, as far as stepchildren, U.S. citizens and green card holders can petition for their stepchild to immigrate, much the same as they can for a biological child. They can also petition for their child to adjust status inside the United States, which is filing the 485 to get a green card. The caveat here is that the child's parents must have married. So that's the birth parent and the step parent must have married before the child turned 18. So I mentioned there are some interesting nuances in immigration definitions, and this is one of them, where it changes a little bit depending on the kind of application you're filing. In some cases, there's a law called CSPA, which is the Child Status Protection Act, and this can freeze a child's age in place to sort of preserve the age that they were before that 21st birthday. So many of you are probably very aware that there are huge, huge long backlogs at USCIS and as well at the Department of State for immigrant visas. This means that often an application is filed on behalf of a child, but the child has aged out by the time the application is actually processed and adjudicated. And because of that, the child is no longer eligible to immigrate as a child, and they have to go into a longer wait preference category. The Child Status Protection Act freezes that child's age in place for purposes of the specific application. And so generally that age is the date on which the I-130 or the I-360 was filed with USCIS. The child does have to remain unmarried to qualify. So turning either 18 or 21, depending, and then marriage are going to end that child status and are going to move the child into a new category in terms of how they have to go about gaining their green card. So as far as, is there a minimum age or a specific age a child needs to be to qualify? So for certain categories, yes. As we've just talked about, there are specific definitions in U.S. immigration law that tell us who counts as a child for various applications. Generally, it's going to be someone unmarried and under age 21. On the other hand, there's no minimum age for a child to have an application filed on their behalf. So if you have married, you have had a child, and you'd like to immigrate your child, you can file that paperwork essentially as soon as you have the child's birth certificate in hand. Once you have the documentation showing your relationship with the child, that the child exists, of course, and so on and so forth, you can go ahead and begin that process right away. You don't have to wait for the child to reach a minimum age. But as I noticed before, there is a cutoff age for children. And so generally you're going to want to act sooner rather than later, because there can be complications if you wait too long and the child is unable to go through the shorter process and has to go into a preference category later in life. As far as a certain age, are there still fees to apply, or is it free? So in general, there are still going to be fees to apply, but they're going to be somewhat reduced for certain situations. The most obvious fee change that you're going to see is actually the biometrics fee. Children 14 years old and younger do not generally have to have biometrics taken. Biometrics are photographs that are used to confirm the identity of someone, often by using biometric measurements, such as the distance from the chin to the ear, distance from the eye to the ear, etc., as well as taking fingerprints. Children age 14 and under generally are still growing quite quickly, and so there's limited utility to these biometric measurements, and so they often aren't taken. And so for that reason, there's not a fee. There is also a reduced filing fee for the I-485, which is the green card application form in the United States. The fee for that is generally going to be $750, so it's a little more than half of the normal filing fee for Form I-485. The caveat there is that that only qualifies if the child is also filing with at least one parent. If the child is filing a 485 alone as a standalone, it is the full fee of $1,140. In general, this is, you're often going to see, similar to how a child can ride along on an I-130 petition, sometimes that also means that they're able to avoid that additional fee. So in the case of an LPR green card holder parent who is sponsoring a child, if the child is able to be a derivative beneficiary on the parent's petition, they are not going to need that separate petition, and therefore there's not an additional fee for that petition. So it's not that the fee is waived, it's that the whole petition in that specific situation is no longer required because they're bundled with the parent. So as far as fees, there is no fee generally for biometrics for children, and there is a reduced fee if the child is filing with a parent. Now, let me jump back to my questions because I want to make sure I stay on track and get everybody answered. As far as the, lost my spot. So for the G1055, like I said, if you're ever curious about specific fees, that is going to be where you find that information, is the G1055 on the USCIS website. It lists all of the fees for the various forms that are filed, including biometrics and different fee requirements for children under 14 years of age. So I recommend you take a look at that if you do have specific questions about petitions or applications that you are trying to file for your family. Finally, I wanted to grab, where did that question go? We did get some questions about what are called follow to join benefits. And so what this means is it possible for a child to come to the United States or immigrate to the United States without the parent? Can the child move to the U.S. alone? There are situations in when this is possible, and theoretically it can be done, but there are going to be a lot of caveats in a situation like this. It's going to depend on a few different factors. It's going to depend on the laws of the child's home country. So there are international conventions as well as laws in place in other nations to prevent parental abduction or to prevent loss or exploitation of children. So for example, to prevent one parent from absconding with a child in the middle of the night and moving out of the country, never to be seen again. So for example, certain countries won't issue a passport unless it is clear that both parents have given permission for this child to exit the country. Convention travel documents, passports, things like this frequently do require a showing that the custodial parent is the one making the request on behalf of the child. So there are often rules about to protect the child, to make sure that the child is being taken out of the country by a parent who has protective custody. So it is something that frequently you're going to have to look at the rules in the country from which you're coming. In general, anytime you're dealing with something like that, it's very advisable to speak with a knowledgeable professional, an immigration attorney or somebody like that, to make sure that you don't run into something unexpected when you try to exit the country or when you arrive in the United States. There are also a few issues in terms of protecting the left behind rights of the parent, and so that's something else to consider as well. You may be familiar in the United States, there are often consideration given, in divorce proceedings, for example, for where is the child going to live? Is the child being taken out of the state away from the parent? If you think about it in that context, then you're going to see some similarities to how these issues are thought about in other countries. So it's just something to keep in mind. Another issue that can come up in terms of sending the child alone is there is a separate issue there in terms of unaccompanied children. Those usually fall, unaccompanied minors is an entirely separate conversation. That's going to fall outside of the family-sponsored visa topic that we're sort of focusing on today. And so for those of you, though, who have seen stories in the news about children arriving, for example, at the southern border and things like that, often the case there is that they are sent without a pre-filed petition, and so they fall under a different process in the immigration system, separate from what we're talking about here. But I did want to mention that there is that program as well. Another question I wanted to touch on was, once your child has received their green card, what happens next? When can they naturalize? So one of the questions that we received was regarding a child who was approved for their green card through the parent's marriage to a United States citizen. Congratulations, by the way. So generally, an immediate relative of a U.S. citizen can naturalize 3 years after becoming a green card holder, so long as the relationship that was the basis of that green card is still in existence. So if you got your green card based on marriage to a U.S. citizen, you have to still be married and living in marital harmony with that U.S. citizen at the end of those 3 years. At the end of 3 years, if that is the case, and you otherwise are eligible, you can apply for your naturalization, apply to become a citizen. In general, if your child received their green card as part of your petition, they are able to ride along with you. And so what this will mean is that the child, in general, will automatically gain citizenship under the Child Citizenship Act if the child is still under age 18 on the date that the parent naturalizes. So let's say, for example, I'm an Australian citizen. I've married an American. I immigrate my daughter with me to the United States, and we both become green card holders based on my marriage to an Australian citizen. After 3 years, I qualify, because I'm still married to my American spouse, qualify to apply for citizenship. If I am approved on the date that I take my oath ceremony, I raise my hand and I swear my oath of allegiance to the United States, if my child is still under age 18, then they also become a citizen. However, in the situation where the child does not naturalize along with the parent, for example, if the child remained in the home country and the parent came to the U.S. as a green card holder, or the child waited until, or for whatever reason is over age 18 at the time that they are seeking citizenship, they are going to have to file a standalone naturalization application, in which case they have to usually have been a green card holder for 5 years on the date that they file the application. So I know that's a lot of information, but if it's 3 years for the spouse, and the child, if under 18, can generally ride along, otherwise you're looking at 5 years to wait. Now, I believe we got a few more questions rolling in while we were chatting about some of these other topics, so let me just have a look over here and see what we got. I did the fiancé visa before and was also a co-sponsor. My question is that I want to do the fiancé visa again, but do I have to add the people I co-sponsor on the affidavit? So that one is a little bit more about sponsorship questions related to the I-134, which is the affidavit of support that is used for the K-1 visa, which is the fiancé visa referred to here. In general, on any affidavit of support, including the I-864 for the DS-260 or the I-485, you do need to list anyone for whom you have co-sponsored in the past up until the point they've become a United States citizen. So for example, if you were previously married and you sponsored someone for a green card and then got divorced, but they are not yet a United States citizen, technically the I-864 contract is still in effect, and so you do still have to list that person when you're filing your new petitions. So it's something to keep in mind. Honesty is always the best policy, so take a really careful look at the instructions that USCIS provides with either the I-134 for the K-1 visas or the I-864 for green card applications. They are very long, very dry, but they will give you a clear idea on what the parameters are. But in general, you do need to disclose prior people that you've sponsored or co-sponsored. Another question I received, does a child have to have the same last name as the parent who is petitioning for a green card? No. In general, the most important thing is to show that there is what's called a bona fide familial relationship. So that can be shown in a number of ways. Often it's shown by which parents' names are listed on the birth certificate. They can be shown through DNA testing, and then what's called secondary evidence. So this could be evidence such as baptism records listing the parents' names, other religious records that should reflect both parents, school enrollment documents frequently reflect both parents, and so on. In some cultures, there is not a sort of familial name that is a through line through generations. In the sort of more English or West American, we have this sort of family last names. Other cultures take sort of names from paternal and maternal, but some don't at all. In general, there's also the option that people can change their names. And so as long as the government can see that there is a bona fide, true family relationship between your child and yourself, or your stepchild and yourself, as the case may be, then that's really what's going to control, and it's not necessarily going to be about the name. That can help show a piece of evidence, but its probative value is definitely outweighed by other evidence you can show. I'm perusing to see if we got any more questions here, so excuse me. Hi, everybody. It's been so nice to have you all joined. So I did get a question that somebody had asked, what ages are considered for a child? So we had touched on that briefly, but it's a big part of this discussion, so I will come back to it again. A child is generally someone who is unmarried and under age 21 for U.S. immigration purposes. There are some situations in which 18 can be the cutoff, but in general, 21 and under and unmarried are the key points for a child in immigration. Once they have to file their own application, that is generally going to happen if they have aged out for some reason, or if they have waited to naturalize. For example, if a parent naturalizes and the child is over 18 at the time, they'll have to file their own application. The USCIS has a few pages that have relatively helpful information, very in-depth information about the definition of a child. It can be a lot to parse through, but it is often good to get this information straight from the horse's mouth if you are curious for some extra details. The USCIS policy manual has a page fully dedicated to the definition of a child, which has a lot of information also relating to adopted children, which can get a little tricky as well. So I did just want to mention that in case anyone was curious about where they can go get more of the official information. Another question we've received, can a conditional green card holder file for a child of 21 and 2 kids below 18 years? So this one is going to be a matter of, in general, once the child has reached age 21, they are no longer a child for immigration purposes. And so they're going to move into one of the preference categories that I had mentioned earlier in our discussion. So those are categories like F2A, for example. So there'll be second preference, third preference, fourth preference, and so on. And this can include not just adult children, but also parents and siblings and so on. So there is no reason that a conditional green card holder can't file a petition for a child who's age 21. It just means that the 21-year-old child is going to be processed probably at a different rate than the other under 18 children because they're going to fall into a different preference category. The Department of State releases visa bulletins that are going to give information about how long those waits look, but depending on the category, they can be quite long. The F2A category, however, has been current for nearly 2 years, and so depending on the category, the wait might not be as bad as it could be. For kids below 18 years, they can also be filed. If there are questions about the child potentially aging out because they are close to turning 18, or even if the child is maybe not that close to turning 18, maybe they're 16 or 17 years old, it's important to keep in mind that the USCIS is suffering from crisis-level backlogs. We're seeing applications processing that used to take a couple months are now taking well over a year. In some parts of the country, green card applications are taking 2, maybe 3 years. New York City has huge huge wait times. So if there's a concern that your child is going to, or that a child is going to age out before an application is actually approved, highly recommend that you seek the advice of an immigration attorney who can provide the best, most concrete advice on how you should handle that, so that your child doesn't get caught out in the cold, doesn't have to file a standalone application at, more expense, greater waiting processing times. It can really cause a lot of complications. And so I highly recommend that if you're feeling unsure, or if you're concerned that your child might age out, that you do consult someone, an ALA attorney in your area who can give you that information you need to take care of your family as best as possible. And on that note, I'm taking a final sweep. I'm not seeing too many more questions, but if anybody has something they wanted to drop in, please go ahead. I'm just taking one final scan. All right, everybody, I am not seeing any more questions right now. If you do think of any additional questions, or you are looking for more information about getting your green card, applying for a fiancé visa, or bringing your children into the United States, the Boundless website has a huge amount of information, and of course we are always standing ready and waiting to answer questions and help folks with this process. Please feel free to reach out to us through our social media. You can hit us up here on Instagram, on Twitter, or on Facebook. Visit our resources at boundless.com. Sign up for the Boundless newsletter, and stay informed. We are always here to provide information, and I wish everybody the best. Have a wonderful day, have a great weekend, and take care out there, everybody.